let's now to move to the rule of the private international law, BIL or PIL. So what point does BIL become critical in arbitration proceeding, and also particularly in a complex cross-border disputes?
That's a very important and very frequent question. And the answer is that private international law, as it's sometimes called, is important from the very beginning until the very end of both the arbitral process on the one hand, but also international dispute resolution more broadly. And let me try to explain both those points. First, private international law, if one by that means conflict of laws, choice of law on the one hand, issues of jurisdiction on the other hand, is ubiquitous or pervasive throughout the arbitral process. I referred previously to needing to choose the law governing the International Arbitration Agreement. That involves choice of law rules. One looks in books such as Dicey Morris and Collins on conflicts of laws and finds hefty chapters on the law governing the International Arbitration Agreement. Once one gets into the arbitral process, private international law concepts, again, principally choice of law, apply with respect to choosing the substantive law governing the party's underlying dispute, whether it's a contractual dispute, what law governs the contract, or a non-contractual dispute, what statute applies, what law applies to delict or tort claims. It also applies to issues of procedure. What law governs issues of procedural fairness? What law governs questions of privilege in disclosure, and the like? And thus, private international law rules and concepts are important throughout the arbitral process. I mentioned that there's a second aspect to how private international law is important in international dispute resolution. And that is as follows. Every international dispute is at least potentially subject to arbitration, but also litigation in national courts. Parties not infrequently, having previously agreed to arbitrate, decide perhaps that's not such a good idea. They've agreed to arbitrate in part because they want an expert, efficient, and expeditious dispute resolution process that will be enforceable. I sometimes call these the 5 E's.